All right, testing. Is this thing on? Can you all hear me? All right, good. So, good morning, everyone. Today's guest speaker, Patricia Coburn, is actually an alumna of KPU, and she's also an instructor here. You may recognize her from introductory psychology, research methodology, cognition, or psychology and law. Patricia completed her undergraduate degree here and graduated with a BA honors in psychology. She went on to complete her master's degree in forensic psychology at SFU. Her master's thesis examined the influence of a potential motive to fabricate observers' perceptions of witnesses and memory for information in a legal case. And for her PhD thesis, which she is currently defending at SFU, she continues investigating legal decisions, making with a particular focus on how heuristics and stereotypes influence the interpretation of information in legal cases. Currently, Tricia has 16 publications in research involving topics such as prosecutions in cases of child sexual abuse, issues pertaining to child witnesses, the effect of hindsight bias in legal cases, and how the legal system should handle cases of cyberbullying. Today, Tricia will be talking about factors that may affect the outcomes of legal cases involving children, and whether we should continue to cross-examine child witnesses. After the presentation, we will have a question and answer period with questions open to the floor. We were also supposed to have food here, but it's not quite here yet. It'll eventually be here, and when it does, it'll be kind of in the back, so please feel free to get up and get some food. So for now, I hope you enjoy the presentation, and please welcome Patricia Coburn.
Is this one on?
Yeah, that one's on.
All right. Okay, so hopefully everybody can hear me. I'll do my best to project. Thank you for coming out. Thank you for the lovely introduction. I'm going to talk, my talk's about an hour, we're going to call a break about halfway in between. So hopefully by then food will be here and you can grab a snack during the break. Please feel free to get up if the food comes here during my talk. I'm good with that. And feel free to ask questions during my talk. So totally open. I like a lot of engagement. Most of you probably know me and know that about me, and so feel free to ask questions as I move along, especially if I talk about something that isn't quite clear or maybe that you're unfamiliar with. All right. So today I'm going to be talking about child witnesses, and it's not the most fuzzy, warm topic. I do my best for a public talk to kind of make it as light and non-explicit as possible, so I don't think it's going to be too uncomfortable, but I do remind students that this is something that is sensitive to a lot of people and a lot of students, and I try to approach it as sensitively as possible. And I usually start with a really cute picture of my daughter. Can you hear me if I walk away from the mic? Okay. Because it's nice to see cute pictures of puppies or cute children when we're starting out a serious talk. So this is my daughter, and I show a picture of her not just because she's so cute, because she's 4, and in this picture she's 3.5. And I want you to really get a sense of how young children can be when they testify in a courtroom in Canada. So at 3.5, she's technically old enough to provide evidence in a Canadian courtroom, okay? So at 3 or 4, children can testify in court. Now, Sophia is obviously a very bright, articulate little girl, and I'm confident if that she was questioned in an appropriate manner, that she'd be able to provide accurate and relevant information about an event. But there's a number of factors that could affect her accuracy, and those are the things I'm going to be talking about today. So I'll be talking about how things like age, delay from the event, and frequency might affect children's ability to provide accurate information about an event. And then I will be focusing on some experimental research. I've done some archival research. I'll talk a little bit about that, but I'm mostly going to be talking about research that I've done with children that shows that maybe cross-examination isn't the most appropriate way to get accurate information from children. All right, so here's a picture. This is not one of my children, although it kind of looks like one of my children. This picture of a child in court. And so children can testify in court for various reasons. They might be part of a custody case. Today I'm going to be focusing mostly on the situation of testifying in criminal proceedings. So when children are testifying in the context of a criminal offense. And unfortunately, often when children are witnesses to a criminal offense, it's because they are a victim of some kind of abuse. It's important to understand that when children are victims of abuse or they've made an allegation of abuse, that by the time they actually arrive in court, they'll be interviewed several times. So anywhere from about 4 to 11 times, okay? And the factors that I talk about today could affect the decisions that are made during any of those times. So for example, a parent has to decide whether or not to take the allegation to the police. So a parent makes a decision, or a teacher makes a decision to disclose the allegation to the police. And then the police have to decide whether to recommend charges to the Crown. The Crown has to decide whether they're going to proceed with the charges, and then ultimately the trier of fact, which would be a judge or a jury, is going to make a decision on whether to convict or acquit. So there's a lot of decisions made, and there's lots of areas where the decision could suddenly end the proceedings. Okay, so there are a number of challenges that we face when we're dealing specifically with child witnesses. So these would be relevant to adults as well, but they're obviously kind of exaggerated or emphasized when we're dealing with children. So as I mentioned, we're often dealing with emotional trauma, right? So children have been a victim of some kind of offense, so quite often, or they've witnessed some kind of violence. So there's emotional trauma there, even before they get to court, right? And testifying in court is a stressful experience, even for adults, and it's obviously stressful for many children, not all, but many. And then we're dealing with differences in cognitive development. So we're dealing with an immature cognitive system. So we might see differences, we will see differences in attention. When we are dealing with very young children, they obviously cannot attend to the same capacity as adults, right? And this becomes really obvious if you're working, some of you have maybe worked with children, and you understand that. And so just to really give you some context, a forensic interview might be 2 hours long, right? It might be anywhere from 1 hour to 2 hours long. And yes, they're going to take breaks when the child needs it, but you have to try and get the child to stay focused and attend to the situation long enough to get the relevant information, right? And then testifying in court, they will testify, they'll have direct examination possibly, and then they will be cross-examined, and that could potentially be anywhere from 80 minutes or an hour to an hour and a half long, right? And so with a little 4 or 5-year-old child, I'm sure you can understand that this is quite challenging for them. There's going to be differences in memory systems, so in terms of their ability to encode, store, and particularly retrieve information. So they just don't have the same kind of memory systems in place as adults would. Importantly, children are more likely to make source misattribution errors. So a source misattribution error is when say, for instance, the child reports that they heard something from a friend at school, but really they saw somebody say it on TV. So the information is there, but they make a mistake about the source of where they got that information. And young children are more likely to make those types of errors than adults. Generally, children provide less information overall. Especially if you ask them, free recall questions. And so this is kind of tricky because we know that the best way to get accurate information is to ask them free recall open questions. Tell me everything that you can about what happened. And a 4-year-old will say, if we're talking about magic shows, I'll talk about magic shows later, they'll say, the magician came in, she did a trick, she packed up all her stuff, and then she went home. That's what you get about a 15-minute event sometimes, right? And so they'll provide less information. And in a forensic situation, they have difficulty understanding the relevance of all the information. So imagine if you were going and you're making an allegation to the police and you're reporting a crime. As an adult, you probably have in your head all the things that you're going to say to the police, all the things that are important, all the things that you can remember that are going to help the police to get the perpetrator, the person who, broke into your car and stole your computer. You have all these things. You want the police to find your computer, so you know. A child doesn't understand the relevance of all the information, right? And so they will sometimes or often omit critical evidence because they don't understand that A, the adult doesn't know that information because little kids tend to think adults know everything. And B, there might be information that they don't see as important or as relevant, and so they just leave it out. And as adults or as interviewers, we have no idea what the children are not reporting to us, right? So they'll omit critical evidence to solving a crime. Children are more likely to be influenced by adults, and so they will comply with adults, right? So we know from experimental research that children will provide answers to nonsense questions, even if they admit that the questions are kind of silly. So if you ask children, what is harder, milk or water? They'll provide an answer to that. Even if later you ask them, was that a silly question, was that a smart question, they'll admit that was a silly question, but they'll still give you an answer to it, right? They don't necessarily always ask for clarification. Children will also sometimes change their responses simply if you repeat the question to them, right? So you ask them a question and maybe you just didn't hear their answer. If you ask the question again, sometimes children will think, I must have given them the wrong answer the first time. And so they'll give you a different answer, trying to get the right answer. Okay? They are also more sensitive, partially because they do comply with adults, to the effects of biased interviews. So a biased interview is when the interviewer approaches the questioning with a preconceived notion of what went on. So imagine that you have an interviewer that strongly believes that the child is a victim and the child is experiencing abuse. That is going to affect the way that the interview asks the questions, right? It increases the likelihood that suggestive techniques will be used, that suggestive and leading questioning will be used. Because if you have a child who is apprehensive about disclosing, or just, simply isn't providing information, or was actually not abused, but you have an interviewer who strongly believes the child is abused and sincerely believes they're doing the right thing by trying to get the information by the child, it gets frustrating. And they're going to try, they're going to resort to kind of more suggestive questioning as it goes on, and they're not getting the information from the children. So it'll also increase the likelihood that the child is going to provide an inaccurate report. The more suggestive the techniques are, the more likely that the report is going to be inaccurate. Okay, so there's a long-standing history of children being viewed as unreliable witnesses. And some scholars tie it back to this historical case in Salem, Massachusetts, where a number of girls reported seeing women participate in acts of witchery. And so they reported really kind of fantastical acts. They reported seeing women raising people off the ground, sticking pins in children, just involved in really almost kind of ridiculous acts. But as a result, a number of the women in the town were convicted. And afterwards, some of the girls retracted their testimonies, right? And some scholars will say that this had a really lasting impact on the perceived credibility of children, on children's ability to be reliable witnesses. So that for hundreds of years, it was generally viewed that young children were just very suggestible and that they weren't going to be able to provide accurate reports. In fact, some may say that this lasted right up until the 1980s. So in Canada, children were essentially functionally barred from testifying, specifically in cases of child sexual abuse. Now I say functionally barred because there wasn't any codified laws that prevented children from testifying in court. But there were doctrines and policies in place which made it virtually almost impossible for them to prosecute cases, some cases, and particular cases of child sexual assault to a conviction. Okay? So first of all, there were mandatory judicial warnings about convicting solely on unsworn testimony. So when children testify in court, they're not sworn in, they're providing unsworn testimony. So if all the evidence that they had in a case was the evidence of the child, the judge was required to warn the trier of fact, which is either a judge or a jury, of the dangers of convicting on the uncorroborated evidence of an unsworn witness. So essentially, judges were required to come out and say, it's very dangerous to convict solely on child's evidence. And this resulted in a number of acquittals being entered, even if the jury believed the child, but they were told that this was dangerous. These mandatory warnings weren't abolished until 1988. Okay? In addition to that, we had the recent complaint doctrine, which was not abolished until 1983. And what the recent complaint doctrine stated was that if somebody was a victim of a sexual offense, they were required to report that offense at the first possible opportunity, meaning that they were not allowed to delay the reporting of the offense. If they did delay, the trier of fact, so the judge or the jury, was required to make an adverse inference about the credibility of that person. So essentially, they were required to disbelieve that allegation because it was delayed. Now, that's the starting point, and the Crown could argue, why you should believe the victim in this case. But the starting point is that you must make an adverse inference to the credibility of this information. Now, this was adhered to strictly regardless of the age. So it didn't matter if you're talking about an adult that had maybe delayed disclosing or a child that had delayed disclosing. And it was really problematic. Okay? And I'm going to talk about some research that I've done that will illustrate how problematic this was. Okay? So I've done some case summary analysis. So I use, with other people in the lab, Canadian Legal Days Quick Law, Canadian Legal Database Quick Law, and I search for all judicial reasons for judgments in child sexual assault cases that went to trial between 1980 and 2012. So we essentially collected all of the judicial outcomes that we could find in Canada between 1980 and 2012. Now, Quick Law isn't going to contain all of the cases, but it does contain all Supreme Court Canada cases, most provincial appeal court cases, and many provincial and provincial superior court hearings, right? So there's lots of data available. In the end, we wound up with 4,237 complainants, okay? And we coded them for things related to the hearings and trial and verdict, things related to the complainant, so the gender of the complainant, the age when the offense ended, when they went to court, the accused, so gender of the accused, age, and the relationship, and importantly for this talk, the offense, so the frequency of the offending, the intrusiveness of the offending, the duration, and the delay to court. We had two main categories when it came to delay that we sorted these cases into. So we had cases that were disclosed and prosecuted within 2 years of the time the offense ended, and we just refer to those as CSA cases. And then cases that were disclosed or prosecuted more than 2 years, and often many years after the abuse ended, and we refer to those as historic child sexual abuse, so HCSA. Okay, so just going to point out some demographics here. First of all, notice the average delay in that early reporting category. So even in the CSA, across all of the cases that were in that category, the average length of delay was about 1.25 years, right? So you're seeing, even with those early cases. In the historic category, the average length of delay is about 13.5 years, okay? And there's a real range as well, so hopefully my head's not blocking it. We can see delays anywhere from 2 to 48 years delayed before those cases go to court, right? Importantly, the majority of the cases in the database fell into this category, about 2/3 of the cases. And this is in line with much of the research out there. Delayed disclosing is the norm. People who are victims of this type of offense are more likely to delay disclosing rather than disclosing immediately, right? And so there are implications of this. Obviously, there's practical implications with trying to prosecute a delayed case, right? Evidence is lost if there is any evidence. Most of the time there is not a lot of physical evidence or cooperating evidence, but if there is evidence or other witnesses, it can be lost. It can be hard to find those witnesses. They move. Some of them even die if you're looking at cases that are delayed 20, 30 years, right? Some of the cooperating with witnesses. You have issues with witness memory. Obviously, it's difficult to remember things that happened a long time ago. Really importantly, a delayed disclosure means that the abuse sometimes continues, because sometimes the reason why the abuse stops is because somebody disclosed it. So delayed disclosure can result in the abuse continuing to that child and to other children. And then relevant to this talk are statutes of limitations, which are in the states. We don't have statutes of limitations here for sexual offenses, but in the states, there are still a number of statute of limitations. They're similar to the recent complaint doctrine. There's a limit on the length of time that that case can be convicted. And so, like the recent complaint doctrine, if the case is really delayed, there's really no recourse in the judicial system, right? So there are still a number of states that have statutes of limitations on these types of offenses. A number of states recently, in the last few years, there's been probably somewhere between 6 to 10 states have removed their statutes of limitations, specifically for sexual offenses against children. So this is good that these barriers are being removed, because it prevents these crimes from being prosecuted. So around the 1970s, things began to change. Things began to get better. There was an increased interest in researching real-world problems in psychology, increased acceptance of expert witness testimony in general, and an increased interest in research regarding child witnesses. So there started to be some research being done that showed that when questioned appropriately, children actually can provide accurate and reliable information. And importantly, those functional barriers were removed in the 80s, right? And those barriers being removed were a result of the Badgley report that came out in 1984 by the Canadian government, which said that approximately 1 in 10 males and 1 in 4 female children had been a victim of some kind of abuse. And there was too many legal barriers present for those cases to be prosecuted, right? And so these changes, we think, did have a real impact on the number of cases that could go forward and be prosecuted. So I'm going to show you a figure. This is from the database study that I was talking about earlier. On the x-axis, what I have is the year that the case was heard in court. So the year that a case went to court. And on the y-axis, I have the number of cases that were available in quick law for us to collect. So the number of cases that we were able to find for that year. And you can see 1984, 1985, 1986, there's really no available cases to collect, right? And then look around the late 80s to early 90s, you see this massive spike in the number of cases that are available, right? And we think that the fact that those cases are available is related definitely to the removal of those barriers to prosecution. So you see the number of cases being high for about a decade or so, and then you see it drop down a bit. So we think that, this kind of stability of high number of cases might be a result of some really old cases coming forward and being prosecuted. So once those barriers were removed, a number of old cases that previously couldn't go to court were then moving to the court, and the courts might have even been a little backlogged by those cases. So then after that, you see a decline until it eventually stabilizes. Okay, so the removal of barriers and the changes of attitudes didn't mean that errors didn't occur. Mistakes definitely were made, and some of the most notorious mistakes are tied to the daycare abuse scandals. And there was a number of daycares that were involved in allegations of abuse against dozens of children. So here's an example of one case in the States, McMartin Preschool, California. A number of the McMartin family members were charged with allegations of abuse against children in their preschool, a daycare center. The allegations were first made in 1983. The investigation and the trial continued on from 1984 to 1990. So for 6 years, children were being questioned, adults were the parents were being questioned, people were being tried, people were being accused of abusing a number of children and committing very hideous and sometimes almost impossible acts. Some of the allegations were very outrageous. In the end, this was said to be one of the longest and most expensive trials to date. And in the end, nobody was convicted. All charges were found to be not substantiated in court. It was all entered in as acquittals. Here's another case, a Canadian case, Martinsville, Saskatchewan, 1992. 4 members of the Sterling family, so here's Ron and Linda Sterling, plus 5 other members of the community were charged with 190 counts of abuse against 24 children. Right? So again, another massive trial. We see a lot of these kind of fantastical allegations, some of the acts even almost implausible. Okay? I believe that this investigation and original trial continued on for about 3 years. And in the end, Ron and Linda were cleared, and only their son Travis was actually convicted of any of the accounts. They were lesser counts. There were 8 out of 190 of them. Right? And this is what the Supreme Court of Saskatchewan had to say about this, or the Saskatchewan Court of Appeal, sorry. They said the use of highly coercive and highly suggestive interrogation techniques can create a serious and significant risk that the interrogation will distort the child's recollection of events, thereby undermining the reliability of the statements and subsequent testimony concerning such events. So the court recognized that the techniques that were used in this investigation were too suggestive, were too coercive, and then it results in it undermining the child's testimony. Now, there are lots of theories and debates about what really happened in these cases. Some people still argue that even those very outrageous claims were actually true. And other people will say that none of it was true. And then you have some people say that maybe something did happen, right? We can't really know, right? We don't know base truth. This is an issue in forensics often, especially when you're trying to do research. But what we do know is that the techniques that were used made the children look unreliable and unbelievable. So whether they were true allegations or false allegations, the techniques that were used were dangerous to the case. They put the case at risk, okay? And so that's why we talk a lot about perceived credibility when we're talking about child witnesses, right? We have to do research that looks at things that affect the child's perceived credibility. So when I say perceived credibility, I mean how believable do the children appear? How believable do they appear when they're testifying? It's really important to study perceived credibility when we're talking about cases of child sexual assault because, as I said previously, often the child story is the only evidence that's available, right? So all we have as evidence is what the child is saying, right? And so if the child is not perceived as credible, it's not very likely that there is going to be a conviction in the case, even if the allegations are true, right? When we study credibility in the lab, which is often done with undergraduate students, sometimes we'll go out to the community, we'll ask, just people in the community. We give people a vignette. It includes children that are young, maybe 4 or 5, and children that are older and adults. And we ask people to rate, how believable are the children? How honest are the children? How suggestible, how susceptible to suggestion would the complainant be? Because we might have an adult condition, right? Generally, what we find is that children are perceived to be more honest than adolescents or adults, right? But they're perceived to be more susceptible to suggestion than adults, right? So honest, but suggestible. The experimental research is consistent with the very few studies that have been done with real judges. So those rare studies that can happen with judges will also say that they perceive children as being more honest than adults, but are skeptical of the evidence provided by very young children, right? So that means we need to be really careful about techniques that could activate those beliefs about children being susceptible to suggestion. We don't want to introduce anything in the investigation, in the interview, that could increase that perceived suggestibility. A good interview might improve accuracy. It might increase the chances that the child will provide more information, including the disclosure. So if you have a child that is hesitant of disclosing what they previously disclosed, so a good interview might help with that. And it might increase the perceived credibility of the child, right? So some good interviews have been developed. I'm just going to talk about one of them today. It's the NICHD protocol, right? In the introductory phase of the interview, there are a number of techniques or procedures that have been implemented to try and decrease that social compliance that children show, right? So first of all, there'll be some discussion of the truth. Children will be asked to tell the truth, and they will be explained that it's their job to tell the truth. And sometimes there'll be a discussion about whether they understand what truth is, right? They'll be provided with some ground rules. There'll be rapport building between the interviewer and the child. And the child will practice recalling a neutral event, okay? So some of the ground rules, we tell children it's okay to say, I don't know. If you don't know the answer, say, I don't know, right? And sometimes we'll even test them a little bit. So if I asked you when my birthday was, what would you say? You'd be surprised. Some little kids will give you a date, and I'll say, I don't know about that. Are you sure that you know when my birthday is? Right? So you wanna make sure that that child is comfortable with correcting you, right? Tied to that, tell me if you don't understand something that I'm asking you, right? Because children will not always ask for clarification. There's been research done with trial transcripts, and when children are asked ambiguous questions, they don't always ask for clarification or say, I don't understand. They just try to provide an answer, right? So we tell a child, if I say something that you don't understand, tell me you don't understand. And if I say things that are wrong, tell me that they're wrong. If I say something incorrect, correct me. This is really important because a little 4, 5, 6-year-old kid with an adult is just gonna, first of all, they assume that adults are kind of all-knowing, right? And even if they don't feel comfortable in correcting adults. This is not how we socialize children, right? We socialize them to listen to adults, not correct adults, right? Tell me about yourself. So this is part of the rapport building, right? We avoid things like fantasy. We don't ask them to tell us about their favorite TV show, right? We want to tell us about yourself. We want to keep that rapport building down to a brief period because there's evidence that shows that the rapport building goes on too long, it actually affects their substantive interview because they get tired out, right? So, minimal kind of but sufficient rapport building about talking about themselves, and then practice recalling a neutral event. Tell me everything that you did yesterday. And then, can you tell me, and you start with open free recall, can you tell me everything that you remember about the magic show that you saw yesterday? I say magic shows because we use magic shows. Right? Completely open. Just tell me everything that you can remember. Or, can you tell me why you're here today? That's often kind of an opening question in a family interview. Can you tell me why you're here today? Right? The problem is, even with a magic show, like I said, you might get 2 sentences from a 4-year-old. Dazzling Dylan came in, she did a magic trick, she gave us all a sticker, she packed her stuff in a bag, and then she went home for 15 minutes, right? So sometimes you have to encourage them to give you a bit more information, right? So you use open-ended prompts. And what you try to do is build on things that children have previously given you. So you don't introduce new information, you just get the child to expand on what they've already told you. Okay, so you said that Dazzling Dylan did a magic trick. Can you tell me more about that, right? And so that might get the child talking, they might provide you some more details. It might also help cue some other things that they didn't remember at the time, right? So it gets that memory going. And then you can use, more focused prompts, right? More directive. Can you tell me what she said, right? Again, you're really building on what the child has provided you. I'm going to be moving into cross-examination, and it is about halfway through, which I promised would be a perfect time for a break when food is here. So why don't we break for a little bit and get some food, and then I'll continue on. So I'll get started again. Before I get started, does anyone have any questions so far? Yeah, Caleb.
After that landmark case, you actually see a spike in the amount of people that are willing to come forward, especially with negative outcomes.
So which landmark case? Like the
One in Saskatchewan.
Are people more willing to come forward?
Are they less likely to come forward? Do you see any spike or a decline?
So we saw the spike kind of pre-90s, and I think those cases were kind of just part of the spikes. But in the States, there actually was a lot of those types of cases, right? Those are not the majority of the cases that we see, right? The majority of the cases that we see usually involve, they're usually family cases. So the most common relationship is a parent, right? So they're not as, these are the ones that grab the media attention, but in our database, the most common relationship is a parent. There is some community cases, so there's sports organizations, and we did see some like residential school cases, those types of things. And those are the cases that we're more likely to see male complainants, those community cases. Any other questions before? All right. Tell me if there's something you don't understand. Okay, so this, also not one of my children, this is John Henry Wigmore. He's a famous jurist and legal scholar. And he said that cross-examination is the greatest legal engine ever invented in the discovery of truth. It is a fundamental aspect of an adversarial legal system, right? So either it can be an adversarial legal system or an inquisitorial legal system. Inquisitorial legal system, it's less like an argument and more like open inquiry. Right? You don't have two sides arguing their side of the story. We have an adversarial legal system, right? With one side presenting the evidence and the other side testing the evidence, right? And John Wigmore, so did the States. John Wigmore's in the States, and he said it's the greatest invention. It's meant to test the reliability of evidence, right? And it's important to be able to test the reliability of an allegation, right? We don't want people to be wrongly convicted either. We want to be able to test whether or not that person is telling the truth. But many people argue that the main purpose of cross-examination, rather than get at the truth, is just to discredit the witness, right? And so this is done in two main ways. First, with credibility challenging questions. So those are questions which basically seek to expose some kind of motive or some kind of reason why the person might be fabricating the allegation, right? And this is important when we're dealing with children, because often people will think, why would a child ever lie about that, right? First of all, how would the child know about any of this information? This child is very young, and so how do they know about anything related to sex? So how do they know it? And what kind of child would ever lie about it, right? And so part of it will sometimes be trying to demonstrate that there is a motive or there is a reason why, a potential reason why the child would be fabricating, right? Either they're confused, somebody suggested it to them, someone coached them, they are resentful. The other way is to try and incite inconsistencies in the witness's testimony. So try to get them to contradict things that they said previously. And this is done by using complex, confusing, misleading, and suggestive questions. And they're usually asked, at a pretty fast pace, right? So you get these kind of confusing, suggestive questions asked quite rapidly, right? I don't know if any of you have ever been to court or been cross-examined, but it's a pretty stressful experience for an adult. And it is reported to be one of the most stressful components of going to court. So children who have gone to court in these types of cases, they will report two main stressors, and that is being cross-examined, and part of that is being accused of lying, and then the other one is facing the accused person. So those are kind of the two main stressors that children will report. So this is an extremely stressful process for anybody and also for many young children. Children, when they go to court, they may be asked about more than one event or one instance. So just going back to that database research that I was talking about, the majority of the offenses involved multiple similar instances. So the abuse didn't occur just on one time, it occurred multiple times, right? So over 60% of the charges in our database involved offenses that occurred 2+ times, and sometimes as many, many times, extending many, many years, right? And this has important implications for witness memory and testimony, okay? According to the specificity principle, an allegation has to be specific enough to raise it from the general to the specific. So there has to be, it isn't sufficient for you to go into court and say, this is what generally would happen, or a child to go into court and say, this is what would happen. This would happen, then we would do this, and then this would happen. That is not going to be sufficient. Forensic investigators have interpreted this, or interviewers have interpreted this to mean that the witness must provide a specific instance of the abuse. They must be able to talk about at least one specific instance. Maybe it's the first time, maybe it's the last time, or maybe it was a time that was subtly different, but they try to get the child to talk about specific times, okay? When we talk about memory for repeated events, this is actually like really super complicated, and I'm going to try and simplify it and demonstrate it as best I can. We talk about different kinds of details. So we can have fixed details, and those details remain the same all the time across all instances. So an example of a fixed detail would be every time you come to campus here, you always go to that one parking machine at the front of Fur, wait in line, and buy your ticket. You do it the same every single time you come. So that's a fixed detail, right? And people who are reporting about repeated events, they get those fixed details right. They're reported with high accuracy, high consistency, high confidence, right? But we also have variable details, and those are details that vary in predictable ways across the instances. So, for example, you might buy your lunch every time you come to campus. But one day you go to Tim Hortons, you buy coffee and a donut. The next day you go to Grassroots and you get a samosa and a salad. The next day you go to the cafeteria, you buy a salami sandwich, right? The details are varying across the instances, okay? And then we also have deviation details, and those are details that belong to something distinct that happened. So one time you come to campus, you go to a KPS speaker series, and you have a free lunch. That's different. It's very distinct from your regular routine, right? People tend to remember the deviation details really well. But the evidence suggests that just because something different occurred doesn't mean that you remember everything surrounding that deviation well. So things that were different, you might remember this part really well, but when you leave here and continue on with your regular routine, go to class, your memory for that won't be any better because you were here today. So when reporting on one instance of a repeated event, individuals report variable options belonging to the wrong instance, and we call these internal intrusions. So for example, if I was questioning you, so something happened last Wednesday, and I'm questioning you, and I said, well, what did you eat for lunch? And you tell me that you went to the cafeteria and you had a salami sandwich. But you actually went to the cafeteria and had a salami sandwich on Monday. And on Wednesday, you really went to Tim Hortons, had donut and coffee. So you've mixed up those variable details across instance. you're more likely to be inconsistent about those variable details as well. So the next time I interview and I say, what did you have for lunch on Wednesday? Before you said salami sandwich, but now you're like, oh, I actually think I had pasta, right? So we see a lot of those errors, those things that are kind of similar across instances. Kids will mix them up, right? And they'll be inconsistent across the interviews. Remember, they might be interviewed anywhere from 4 to 11 times. Those types of errors are common. Other errors that we call external intrusion, so reporting things that just never happened, those are less common, right? So it's less common that you'll just report, you know, I went to a restaurant and had sushi, but that never occurred. So you're less likely to make those types of errors. Now, think about the difficulty of reporting on a single instance of a repeated event. Now, imagine being cross-examined about that report, okay? And that's really what my research looks at, okay? So, talk a little bit about the research on cross-examination in general. There's been quite a bit of research on this in the last, say, 10 years. It's a growing research interest. Generally, the paradigm is this. Children witness or participate in some type of event. So they go to the police station for a field trip. After the event, they're given a baseline interview. They are asked questions in a supportive manner. This is supposed to be analogous to what they would be given in a forensic interview. They're later cross-examined by a different interviewer, and the objective is to change the children's responses, whether they were accurate or not at the first time. So they'll be asked suggestive, leading questions to try and get them to acquiesce with the cross-examiner. We're trying to get the children to change their response no matter what. Okay? What this research finds is that the majority of children will change at least one of their responses. So but 25% of responses, if they're only asked for questions, they'll change 1 out of 4. The majority of them will change at least 1. More than half of them will change most of their responses under cross-examination, regardless of whether they were accurate or inaccurate in the first place. So even kids that had the answers right at time 1, when they're cross-examined, they will change their responses and they will become less accurate. Yeah?
Does this vary with age?
It does vary with age, right? So they've done research with just strictly like 5 and 6-year-olds, and then they've done research with 9 and 10-year-olds, the exact same paradigm. It varies a little bit with age, but not that much. 9 and 10-year-olds will still change, you know, the majority of them will change at least 1 response, and many of them will change, you know, half or more of their responses. So it does vary a little bit with age, but not as much as you might think. Okay, so there's some evidence to suggest that children will change their responses even if they have accurate memory for the event or for what they said during time 1. And one of the ways that they've tested is they give children a 3rd interview. And this is similar to what might be done in court. The kid provides the child provides their direct examination, they're cross-examined, and then they're redirected by the Crown again to try and rehabilitate the child's testimony. So this is similar to what's done in court. They've done it in an experimental setting. They give the child a 3rd interview. After cross-examination, they say, just report the answers exactly as you remember them occurring. Okay? And what happens? The child provides the answer that they provided in the first interview, and their report becomes more accurate again. Importantly, this redirect interview is done with the same interviewer that was used for time 1, and you're using those supportive techniques. So with that supportive, same interviewer, children will report what they reported at time 1, and their report will be just as accurate in time 3 as it was in time 1. Suggesting that children are changing their responses under cross-examination in spite of them actually remembering what happened. Okay? It suggests that they're changing them due to these social factors. They're simply complying, they're simply acquiescing with the cross-examiner. Okay? Research up until now has only looked at this with children experiencing one event. Yeah, Wes, do you have a question?
So for the third interview, you're using the same interviewer as the first one. If there was a different interviewer, do you think that the answers would change?
So a third interviewer or the same interviewer?
If you use the third interviewer for the third interview, using the same techniques as in the first, because I kind of wonder if maybe having the person reminds them of what their answers were, right?
Yeah.
And if you ask the same questions in the same tone with the same person, it might jog their memory about the first answer as opposed to the actual.
So the interviewer is serving as a cue to help them remember. Okay, so here's something. I do think they would be just as accurate with a third interviewer, even if as long as they were supportive and used appropriate questioning style. So here's something that I should tell you. When children are cross-examined, they've done research where they will actually play a videotape of their first interview for them. So their memories will be refreshed right before cross-examination. In my research that I'm going to talk about, we actually tell the children what they said during their baseline interview. So when we asked you this question the first time, you said it was this. So we actually give the child what they said during interview 1, and they still will change their response. So I don't think it's that the interviewer is serving as a cue. I think it has more to do with the questioning style and those supportive techniques. Does that answer your question? Okay. So to date, research has only done this with single event children, and I was interested in, will repeat event children, given the difficulty there is in reporting a repeat event, will they be able to respond with their initial answer during the third interview? That's what I was really interested in. Will a redirect interview rehabilitate children who have experienced a repeat event? Okay? So I tested children who had participated in either 1 or 5 magic shows. I told you we use magic shows. And for the children that participated in 5 magic shows, they participated in 1 show a day for 5 days in a row. And each one of these shows had 12 of those variable details. So those are things that changed in a predictable way across the shows. Okay? So for example, every day the kids did a warm-up exercise, right? But on one day they did arm circles, the next day they did jumping jacks, the next day they did stretching, the next day they did sit-ups, and the next day they did running in place. So those details are varying in a predictable way across the 5 instances. And we had 12 of those things, right? So they would get a sticker and the magician would put it on a part of their body, right? So those are the 12 details. So children either participated in 1 magic show or 5 magic shows. 1 week later, they received a baseline interview. This is the same as their direct examination. We used a version of the NICHD protocol, so we gave kids all of those ground rules. We did a practice, we did rapport building, we gave them a really good baseline interview. Same for all children, okay? Immediately following that, half of the children were cross-examined. We used 8 questions to try and change 6 of their details. Try and change their responses on 6 of those details. So we would say to them, when you first answered this, you said this. And they would say yes. And then we would say, but are you sure it wasn't this? No, it wasn't. Well, how do you know that? Well, when did that happen? And we would ask them at a pretty fast rate. If they didn't answer within 2 seconds, we moved on to the next question. And then finally, we would say, but if your teacher said it was actually this, she'd probably be right about that, wouldn't she? And some children at that point would say yes. Yes, that's the way, right? And they will use those kind of social factors to convince witnesses that it's actually this. It'll sometimes happen in an investigation. Well, I heard it was this, or another child said this. Or if the child with the best memory said it was this, do you think they would be right? Yes. Many children didn't make it that far though. All you had to say to them was, are you sure it wasn't this? Are you sure she didn't actually remove her backpack? Oh yes, it was her backpack, right? The other half of the children, this is my control condition, they're simply re-asked all the cue to recall questions again. So we simply just ask them, what did you do for a warm-up exercise? Where did the sticker go on your body? We just ask them again. It's a different interviewer though, but they're just simply asked all the questions again because we want to make sure that children aren't changing their responses only because we're asking them about it again. And then finally, so this is a different interviewer than here. Finally, a few minutes later, this interviewer comes back and gives the children a supportive redirect. All children get a supportive redirect. Okay? They're simply asked the question about these 6 details again. What was a warm-up exercise you did? Where was the sticker placed on the body? What was the special goodbye that day? What was the secret she told you? Just straight up. Okay, so here's some results. Okay, this is accuracy on variable details. On the x-axis, I have my cross-examination condition and my direct condition. So this is my control condition, right? Interview 1, interview 2, interview 3, interview 1, interview 2, interview 3. Okay. Significant difference during interview 2 for my cross-examination condition, and no differences for my direct condition. In fact, these children are actually getting a little bit better by the 3rd time that they're being asked these questions. So simply being asked the questions over and over again is not affecting their accuracy. It is this suggestive and leading questioning that affects their accuracy. Okay? I'm not showing you all of my figures because we only have this room until 2. I didn't even tell you all of my variables because somebody very wise said, try and simplify your talk as much as you can. Yes, Daniel?
Could it be that kids are more obsessed with trying to look for validation from adults?
Yeah.
Depending on the adults, like if they're influenced by?
Yeah, and that's probably it. That's probably the fact that they're sensitive to adults. When an adult is saying to them, but don't you think it could be this? They will easily just acquiesce to that. Yes, I do. I actually think it was this.
They're not being 100% honest. They're not being 100% honest, but they're rather
That's right.
looking for the validation.
They might be just changing their responses, and that's what all of the research to date says. They're just changing their responses due to those social factors. They actually remember what happened. Okay? Here's accuracy for deviation details, and this will be different. This is going to kind of be different than what I just told you. These are my single event children. So these are children that only experience one magic show. These are my repeat event children. And what I want you to look at are the children that were cross-examined in both of those conditions. For the single event children who are cross-examined, there's no difference in accuracy between interview 1 and interview 3. So that redirect interview rehabilitated their accuracy for deviation details. Even though they changed it during the cross-examination condition, the 3rd interview they're accurate again and there's no difference. Not the case for my repeat event kids. Once the repeat event kids changed their response under cross-examination, the redirect did not rehabilitate their accuracy. So they were still less accurate in interview 3 than they were in interview 1. Okay? They're more likely to maintain that suggestion that was given to them by the cross-examiner. Okay, so just a little discussion of that. Repeat event children were less accurate overall, and they were also less consistent than single event children. So they were more likely to change their responses across the board than single event children. Cross-examined children were less accurate and less consistent than children who were asked repeated event questions. And a redirect interview did not always rehabilitate accuracy, and this might be worse for children who had experienced a repeat event. Okay? Now, I said that it's important to also look at perceived credibility, right? So we have that cross-examination is definitely not good for the consistency. Children are changing their reports. It's not good for accuracy. They become less accurate, right? Even with a redirect, they might be less accurate. But what does it do to their perceived credibility, right? Will it make them look less believable in court when they're cross-examined? So even if they're telling the truth, because when there's no other evidence, people will often look at how consistent a witness is. So a consistent, confident witness will be perceived as more credible than an inconsistent, unconfident witness, right? So that's what we did next. We looked at the effect of cross-examination on the perceived credibility of these children. And so how we did it is we took 5 videos of those kids for each of the conditions, single event or repeat event, cross-examined, or the control condition. We took 5 videos of each one of those. And then we asked 530 undergraduate participants to watch one of those videos. And they rated the perceived credibility and the child's susceptibility to suggestive questioning. Okay? And so what we thought is that children who were cross-examined would be perceived as less credible than children in the control condition. Repeat event children would be perceived as less credible than children in the single event condition. Cross-examined children would be perceived as more susceptible to suggestive questioning than children in the control condition. Those were my hypotheses. And this is what we get. Ignore this because I'm not talking about age. It's the one factor that I just left out to try and simplify my talk a bit. But you can see that single event children who had just experienced one magic show, were perceived as more credible than children who had experienced multiple magic shows. Now, you might think, well, they were more accurate. They should be perceived as more credible. What is important for you to know is when I selected my 5 videos, I chose videos of kids who were all equally accurate, no matter their condition. So I matched on accuracy. So for this study, at least during interview 1, the children were equally as accurate in reporting details that they had actually experienced at some point. Okay? And still, single event children were perceived as more credible than repeat event children. There was no difference in credibility whether children were cross-examined or in the control condition. And I actually had 3 measures of credibility. I asked about perceived honesty, perceived accuracy, perceived credibility, and there were no differences. Not even a smidge. Not even close to significant. No differences. There was one difference. When children were cross-examined, they were perceived as less susceptible to suggestive questioning than children in the control condition. People actually rated them as less likely to be susceptible to suggestion than children who were simply asked all the questions again. Completely counter to my hypothesis. So, cross-examination has negative effects on the accuracy and consistency of children's reports. Children who are cross-examined were less accurate and less consistent in the first experiment than children who were not cross-examined. But there was no observed effects of cross-examination on perceived credibility. And this raises a question of whether jurors are sensitive to the type of questions that children are asked under cross-examination. Are they sensitive to those suggestive techniques, and then are they then adjusting their evaluations of the children for that reason? Okay. Got about 5 more minutes, and then I'm going to open it up to questions. So people will ask, is there any kind of support for children who are being cross-examined? So one area that we've done really well in, I think, since the 1980s is implementing testimonial supports for children. So children will be given a testimonial support upon application. It has to be given to them. So there are accommodations that are made to witnesses in court. They are used to provide a full and candid account of the event, so they are meant to help the person provide more accurate information. It reduces anxiety associated with testifying. It cannot interfere with the proper administration of justice. So people have tried to say, you know, I have a right as an accused person to face and confront my person who is making the allegation against me, and the courts have come out and said, no. You know, testimonial supports do not interfere with that right. It is simply just in some instances like a screen between you and the child. And it must be allowed upon application. So here are some of the testimonial supports that will be used during all of the testimony, including the cross-examination. A screen, so a screen just goes in front of the child so the child can't see the accused person. And sometimes it's set up so that the accused can still see the child. Don't ask me how that works, but that's apparently how it works. CCTV, so a child testifies in a different room with the lawyers, and there's, there's a television screen or a computer screen in the courtroom, so everybody can watch the child testify, but the child doesn't have to be in the courtroom. And that seems great, right? Keep in mind, yeah, in Vancouver, we might have access to that kind of testimonial support, but the further you get out and the more remote, not all courtrooms are going to have this type of technology available to children, right? A support person, so a child can bring someone to court with them to be a source of support for them. A videotaped interview, so commonly their videotaped forensic interview will be submitted into court in lieu of direct examination. So they will not have to be questioned by the Crown again. That's basically their side of the story, and that can just be submitted into court. The child listens to that and has to adopt the contents of that videotaped interview. Importantly, though, the child must be available to be cross-examined on the contents of that. So the child will still be cross-examined even if they're admitting videotaped evidence. A closed courtroom, so sometimes there'll be a publication ban on cases involving children. And children, so here's one that's really relevant to cross-examination. Children under the age of 18 years old cannot be cross-examined by the accused person. I mean, so this, I can't believe they actually had to come up with this law, right? So we're not, if the accused person has decided to defend themselves, to act as their own lawyer, they are not allowed to directly cross-examine the child. So that's good. That's good that we've done that part. I think that one's great, but can't believe. So generally, the research shows that testimonial supports will decrease the anxiety of child witness. It'll increase their memory or their accuracy of the report. But there's some research out there that shows that testimonial support actually results in decreased perceived credibility. So you have to think of, you know, the proper balance of using a testimonial support that will reduce that anxiety, but not have such a negative effect on the child's perceived credibility that it's potentially affecting the outcome of the case, right? So it's kind of a fine balance. All right, in summary, many positive changes have been made since the 1980s to support child witnesses, such as the removal of barriers, development of good interview protocols, increased availability of testimonial supports, research devoted to understanding under which conditions children will provide the most accurate information. More changes are occurring and potentially still need to be made, and one big area is research on cross-examination. Some future directions for research that I personally think is a way that we need to go is, can we help decision makers adjust credibility ratings for repeat event reporting? Because we are consistently seeing that adults and children reporting on a repeat event, even if they are as accurate as single event witnesses, they are perceived as less honest, less accurate, and less credible than single event. Maybe if we explain that the person is reporting on a repeat event, so we don't actually come out and say this person is reporting on a repeat event. Maybe if we explain how memory is organized for a repeat event, talk about how difficult it can be to be consistent on a repeat event. Another thing we need to do is kind of examine what the prevailing perceptions and attitudes about cross-examining child witnesses actually is. I'm surprised often when I talk to people about, because I say, like, do you think that we should be cross-examining child witnesses? Many people say, we do that? Like, they don't know, right? And so I wonder, why there isn't more of a conversation about whether or not we should be cross-examining child witnesses. And finally, test some viable alternatives to cross-examination. So maybe talk about what viable alternatives are, but importantly, test those viable alternatives. Does it help with accuracy, consistency? What does it do to the perceived credibility of the child? All right, so there are some references that I used for this talk. I'd just like to thank all the members of KPS for inviting me here to give this talk, and very busy time of their semester putting on this talk. You, the fantastic audience, Dr. Dana Weewood, who is my colleague that we collected our data together, because we actually collected 800 child interviews for our two dissertations. So that was a lot. All of the children in Burnaby from kindergarten to grade 5 had seen our mapping shows. We hit every school. And then Dr. Connolly, Dr. Bernstein, and Dr. Alder, who are my committee supervisors in my dissertation work. All of the teachers, children, and parents. There's very, very many who participated in this research, and the many, many, many research assistants in the Children's Memory Lab that helped with this research. Finally, I just came up with a couple of questions that maybe my students that are here today will know that this is something I like to do, is for the speaker to kind of develop questions to help generate some talk. So, should we continue to use cross-examination to test the reliability of the children's evidence? And should we have different expectations for reports made by children who have experienced multiple similar instances of abuse? Those are just kind of two questions that I came up. I will remove them so that hopefully they don't totally influence the questions that you're going to ask. Okay. Questions? Wes?
So you mentioned that sort of things that help reduce the anxiety in the courtroom can also affect credibility. Do we know which ones most severely affect witness credibility?
Yeah, so it seems that the further away that the child seems, one of the hypotheses is that there's this distance, and the further away that the child seems, the more negative effect it has on their credibility. So a screen might have less of an impact than, say, CCTV, where the child's completely out of the room, right? So, but all of them are lower than live testimony. Yeah.
So, I just had an idea while you were speaking. Why don't we put the screen in front of the accused? Because I find that one of the reasons we're putting the screen up in front of the child is that, you might want the cues of honesty from being able to see their face
Right.
while they're responding.
Right.
But that's not a problem for the accused. So you put the screen up in front of the accused person, therefore the child wouldn't be able to see them, but we would still be able to see the child while they were responding to the questions.
Well, the trier fact should still be able to see the child. So if the judge is sitting here and your witness is right here, the judge will see the child. The judge will see the child, or the jury will see the child. The child just can't see the accused person. And I don't think that it would be, I think there would be an argument for an interruption to the proper administration of justice if you put a screen in front of the accused person. The accused person has a right to be there and see what's going on.
Yeah, well, you can do one of those two-way screens.
Yeah, I guess so. Any thoughts on whether we should be cross-examining children?
To me, it is obviously one of the, if you're in charge of children, you can see, you're stressed out for them, watching that. But I'm just thinking, how often do people unearth that maybe a child, that something didn't happen, but it became out of fantasy due to proper cross-examination or I don't know exactly
Right.
how often it works out properly, you know what I mean?
Right. So Amanda was saying, it's on its face, it does seem very stressful. Correct me if I make a mistake. It seems stressful and you feel stressed out for the child, but she said, I'm not really aware of, how often we'd be dealing with a false allegation where the child is, alleging or there's a risk of somebody being falsely convicted, right? And we do need to protect that. Of course, we don't know base truth. We don't know how many allegations are false. The research that has been done in this area thinks that the number of false allegations are very, very low. It shows that, the research doesn't think, but it shows that they're thought to be quite low. Here's something that we are pretty confident in knowing. There are far more children who never come out and disclose abuse that occurred to them than children who come out and disclose abuse that never happened to them. Yes, Samuel.
Could it be that some kids can be almost afraid that they're going to be ashamed by the idea of exposing something that might not be all sunshine and rainbows?
For sure. There are lots of reasons why children don't disclose. One of it is the shame, the emotional component to it. There's some really recent research that shows that children will reflect on the consequences, so potentially being harmed, right, if they have been threatened to keep quiet, potentially being removed from their own home, right? That's a potential consequence, right, if the abuse is occurring. So there's lots of reasons why they wouldn't disclose. And there's fewer reasons why children would disclose something that never occurred. And remember, their information is being tested along the way, right? Not all cases, in fact, very, very, very few cases go to court in Canada, right? Most cases are resolved through plea bargaining. So only a small proportion of cases actually go to trial. Yeah.
How old did you say children could be before they are brought into the system?
They could be 3 years old.
Okay. Because if I remember my psychology properly, around that time is when children start developing the ability to tell that other people have different thoughts to them.
Yeah.
So, I guess my question is, would it be a better idea to increase that age, or is there things we can do to kind of make that more reliable for children?
So to change the age at which they could be competent witnesses. Now there is no set age. Children are assumed to be competent to testify. It can be argued that the child isn't competent and they'll do a competency evaluation, but the threshold is quite low. The child just needs to be able to communicate the evidence, right? So a child who's 4 that is not able to communicate properly will not be testifying in court, right? A child who's 3 and very articulate, I've seen some very articulate children, 4-year-olds and 3-year-olds. You know, I'm quite confident my 4-year-old could testify if she said anything. I'm not really sure she would say anything in court. And she could lie. Like, I know she could, right? But, so I'm not sure of changing. And in fact, perceived credibility, of the research that I've done, perceived credibility is lowest out of all of the age groups across the lifespan that I've looked at. What do you think the lowest perceived credibility is? Teenagers. Adolescents. especially in this context, adolescents have very low perceived credibility. They are perceived as less honest than younger children and even adults, right? So they're actually kind of at risk for, I think, stereotypes that are associated with adolescents. Hold on, Samuel, Supal is...
I just want to say, like, I remember we brought up at one time in class where there was an experiment and they were just basically focusing more so on children under the age of 12. I feel like they could be more age sensitive, because I remember we discussed about how, like, I monitor children and, like, of course, this is what I've just generally seen, like, each age, as, like, they go from 6 to 7, it's like a huge cognitive
Right.
ability, right?
Yeah.
I feel like it wouldn't be enough for them to just be coherent enough to, like, express themselves.
Right.
I feel like if there was, like, more of, like, an age thing and more, like, precise with the age and how they assess that
Right.
person's age would be better than just being like, oh yeah, they can express themselves with their age.
Right, and that's a very good point. So a number of countries, what they're doing is they're using communication facilitators. And it seems, I've done some research on it, and it seems part of the job of those communication facilitators is not only to attend court and help to clarify questions for the children, is to assess their communication abilities before they're interviewed, before they go to court. So to actually do like a comprehensive assessment of the child of what types of supports they might need, what their communication level, rather than just a really quick, can this person communicate basic information to us. So that is one of the things that's been implemented. I've looked to see if we're using them in Canada. It doesn't seem that we are using any kind of, I mean, they're going to do an assessment with children. One of the kind of sad realities of this is that children who maybe suffer from a disability, or maybe they're nonverbal, they're more vulnerable to being victimized. So they're at a higher risk to actually being abused. And then if you consider their ability to provide evidence, to potentially even go to court, be cross-examined, it's not very likely that they are going to be able to stand up to those techniques that we're seeing under cross-examination. So it could mean that those types of victims are less likely to be able to even go to court or to have their case heard. Daniel.
I wonder if there would be some compensatory considerations in those cases, similar to what we see with the perceived credibility. If the disability was the type that was focus, like it was obvious,
Right.
that there was a disability present, though there are
Right.
lots of disabilities that are hidden.
Right.
In the case where it wasn't so hidden, I wonder if there would be compensatory mechanisms.
Right. Right. So I think that's an important point. So Daniel said, would there be some kind of compensatory mechanism in place for the perceived credibility of children who maybe have an outward disability? Would people adjust, just like we saw in this study, they seem to be adjusting their perceptions of the children based on the types of questions that they're asked. And I mean, legal scholars will also speak to this. And even if you you can go out there and you can find tips on how to cross-examine children for defense attorneys. And they'll actually say, like, you don't want to come off too hard, because then that's going to have a backfiring effect. And so I think there'd be a similar thing with children with disabilities, although it hasn't been tested. It is something I think that is a good area for future research, is to kind of look at vulnerable, even more vulnerable populations under cross-examination and kind of their perceived credibility and that sort of thing. Samuel.
Do you think that male adolescents are more vulnerable in receiving less credibility than adolescent females?
I think it depends on the context.
Because like when given like some sort of like any kind of like reference that, oh, I understand on something towards a case or something like that, do you think that males are more likely to be like viewed as not as credible compared to females?
I think it's really going to depend on the crime that you're looking at, and it depends on also who the perpetrator is portrayed by. So there is some,
Whether it's the perpetrator or
Yeah.
if it's
Yeah.
male or female,
yeah,
depending on who, because I kind of seen through some sort of like ongoing cases through any kind of, if it's social or if it's professional, like in certain cases people are more, in personal experience, I kind of seen how like, I don't know if I'm right or wrong, but like I've seen if by any chance that people have seen people who,
here's what I'll tell you what we've seen. People will attribute more blame to male complainants.
Yeah.
If the accused person was a female, right? And so we do know that complaints of abuse, sexual abuse from male adolescent complainants might be perceived as less harmful, right? So there is that component to it, and I think that could be a real thing in the world, that maybe males in our database research, we do see much longer delays with male complainants than we do with female complainants. So males actually have much longer delays in their cases, and it's interesting. It's an area of research that I really want to look at, because I'm curious if they're delaying because they are reluctant to disclose, or if they actually disclose and they're more likely to result in what we call dead-end disclosures, where people don't take the allegations seriously and go forward with them. I also think that there's potentially more cover-up in cases involving males, because those cases are more likely to occur in community settings. So male children are at higher risk in the community, so things like sports organizations, churches, universities, definitely like sports is a big one, and I think there's some case studies or some famous cases out there that will come out and say, yeah, this is happening, when you're involved in, professional or semi-professional sports, that there's this cover-up. So I do think that there is more to the story, but we do see longer delays with male complainants. It's interesting because we only see them in those cases where the abuse has happened in the community. If the abuse happened from a family member, we don't see any differences in delays between female and male complainants, which suggests to me that maybe there is that institutional cover-up and those barriers that are particular to institutions that are causing those we're seeing really long delays, like 10, 20 years. Yeah.
Perceived credibility, and I can't remember if you covered it, does it increase if their testimony is consistent? So could that potentially be something instead of cross-examination to show how consistent their testimony is?
And I think, and that's, people often look to consistency, because given that you don't know base truth, and so people will often use, consistency and confidence. But we know confidence is not a reliable, not always, right? It can be. It can be if it's assessed immediately after a person does an eyewitness identification. There is some evidence that children's confidence of an episodic event is related to their accuracy, but that same research showed that children's response latency, so how long it took for them to respond, they were using that as a cue as their own confidence. So if it took them a really long time to think about it and respond, they would report low confidence. So it's really how long it takes for the kids to get the answers. But it's still unreliable. There's a lot of individual differences. Confidence isn't a reliable predictor. Consistency might be if it's a single event. I think if it's a repeat event, kids are going to be just terribly inconsistent across interviews within one time. And then the minute that you come up against a child that's trying to report on a repeat event, and you start asking them about these peripheral details, and they will do that. They will ask them, well, how many times, did it happen? And a kid, 15. Are you sure? Like, maybe, was it 13? And the kid has to remember, those little things. Well, I think you said, didn't you say, or didn't this person say that it was actually only 12? Is it possible? Do you know how much 15 is? Can you explain to me how much 15 is? What is that exactly? What exactly does 15 look like? Poor little kid, maybe, showing up like this and 1 foot, right? Like, they will kind of pick on those peripheral details. Those are the exact details that are, that repeat event children are going to be inconsistent on. So for single event kids, maybe consistency could be approximate. But for repeat event kids, they are just really inconsistent. They really have a terrible time at accurately attributing the correct variable detail to an instance. So repeat event kids, all my repeat event kids, whether they were in kindergarten up to grade 5, they got the right variable detail for the instance I was asking them about. So I'd be asking them about the time they saw the rolling dice trick. And then I would ask them, what did Daphne Dillon remove when she performed the rolling dice trick? They only accurately attributed the correct detail 1 out of every 4 times. So I analyzed 4 variable details. Their average was 1 out of 4, which could just be guessing because they experienced it in 5 different ways. Right? So at chance, it's going to be about 20% they're getting it about. So they're really terrible at accurately attributing what you actually ate for lunch 1 month ago. 1 month ago on Wednesday, what did you have for lunch here? You're not going to get it right. If I ask you about it again in a month from now, you're going to give me a different response. Right? Maybe. And if I tell you, well, somebody told me that they were with you at Tim Hortons and you actually bought a scone, right? It's like, oh, did I? Right? Yeah, Matt.
I'm just wondering, do the judge or the jury ever get educated about this type of thing prior to the trial? So they come in there completely not knowing how cross-examination and all that could affect children's...
I mean, I was saying this on the break, I think Canadian judges are really smart people. Like, it's difficult to become a Canadian judge, and all the minimal experience I've had with Canadian judges, they're remarkably respectful, thoughtful, brilliant people. So they probably have an understanding of the effect of cross-examination on young children, right? Juries, maybe. But my research suggests that they are, just undergrad students are sensitive to the type of suggestive questioning. They're, that's what my research suggests. They actually thought that the kids were less susceptible to suggestive questioning when they were asked these kinds of details and cross-examined that way. So maybe people, my research suggests that yes, it's bad for their consistency and accuracy, but it really isn't affecting their perceived credibility, right? I should point out that I went back and I analyzed exactly how many details in my videos that kids changed on. So they acquiesced for about half of them. So the videos that I selected, children were acquiescing for half of them, which means for half of them, they were probably maintaining their response. And so it could be that my 40 videos that I had, those kids did maintain on some of those details, and that helped to boost their credibility, right? So other research could potentially look at the effect of kids that are cross-examined for those kids that just acquiesce all the time. Then we might see differences in perceived credibility. Any further questions? Yeah, Wes.
Well, so earlier we were talking about sort of teenage males, right? And you said, maybe it's, like there isn't later disclosure, these things. I think maybe it's also a cultural thing, right?
Mm-hmm.
So especially, and you said, when it's in the family, it usually happens about the same as it would with a female. I think maybe it has to do with the taboo of it,
Yeah.
right? So when you have a teenage male, right, who's had sex with, a teacher or someone like that, there's a cultural stigma to saying that I didn't want that.
Right.
Right? So they might not feel comfortable coming forward.
Right.
because they think, well, if I do come forward, everyone's opinion of me will drop,
Right.
right? But if it's a family member, they know that this is completely unacceptable,
Right.
and they have an expectation it will be treated the same way
Right.
as it might be with a female,
Right.
because they know that it's not just the sex that was wrong,
Right.
it's who it was with as well,
Right.
right? So it could be something like that as well.
Right, but I mean, you're going to have all sorts of variability, right? That's a very particular instance with a teacher, a teacher child, and the complainant might not feel like they were victimized. It's still against the law. That person is still abused a position of power. And as a parent, if that was my child, I would be mad and I would be like, you know, going for the teacher, right? But that's actually the type of case that we don't see that often. We don't see, in fact, in our whole database, we have very, very few female perpetrators in the database. Now, it could be, possibly, there could be a number of things. It could be because males are not disclosing that. And they could be not disclosing at a higher rate when the perpetrator is a teacher or, you know, just an older female in a position of power. Those might not be being disclosed at all. A female babysitter, right? So maybe it's not being disclosed at all for the very reason you said. It could also be that those cases are less likely to make it to trial because my database, I just collected ones that went to court, whether plea bargain or trial. So maybe they get reported, but the police don't go ahead with them because they think, you know, this is not going to be a very credible witness. You are not going to have sympathy there, right? And then maybe judges aren't really talking about those cases, but I think that third option is less likely. I think if those cases are going to court, that judges would have something to say about them. I definitely think that delayed disclosure in males and certain contexts is definitely an under-researched area, and it's becoming much more important with a number of kind of historic cases that are coming forward now. There's many of them. Rochelle, did you have a question?
I was just gonna say, if it's like a male complainant and a male accused in the community, maybe it has something to do with like perceived homosexuality or something like that, where they don't want to be perceived as that, whereas in your family, you wouldn't think that because that would be.
So I think some of the early kind of theory suggested that, but there's actually not a lot of evidence to support that that's a major barrier. So I think that was kind of like an early, like maybe this is what's going on, and most, I think, of the limited research that is out there specifically with males and delayed disclosure, it's consequences. It's consequences like, you know, I might be harmed. I might be physically harmed. My family might be physically harmed. I might lose the position on the team. I might lose my place in the university. I might lose a place in this organization. I might lose my funding. I might lose my career. It's consequences. More so, I think, than, I do think that there is fear of stigma, but I think those consequences of the recent research that I looked at, it seems that those kind of real consequences seem to be the biggest barrier, right? And then cover up. There's really not. You know, there is evidence that kids did report, you know, and reported to more than one people that, you know, people high up in the institutions knew about it and just were keeping quiet about it to protect a certain person in their organization, right? So I think that there is some work being done about proper reporting within sports and rec organizations now. So that's, you know, really great to see. And,
This one's a little bit out of left field.
Yeah.
But it's just something I've considered because when we talk about, you know, the testimonies in court and with lawyers, I often think about what about before that. So what if you are the parent who are listening to your child saying something for the first time? You also don't want to contaminate whatever information is there. What are the proper questions to ask? Do you go directly to the cops? Like, how do you, you know,
I mean, I have seen some interviews where it comes out that the parent, and some cases where it comes out that the parent was quite suggestive of their, and they don't mean to,
No.
right? They're just panic stricken. And then, I saw one case where it was like, the child said, okay, this happened to me, right away the parent was like, was it this person?
Yeah.
Because I've heard that this
Yeah.
person was doing this.
We have one parent versus the other parent.
Yeah, well, yeah, definitely. But like in this case, the parent automatically inserted name of accused to a
Yeah.
child. So it could be that yes, it was that person. But when it goes to court and they call the witness of the first person the child disclosed the allegation to, which is the mother, and they said, okay, tell me about how that conversation went. The mother says, well, I said, was it this person?
Yeah.
Whether it's true or not, what does that do to the child's perceived credibility?
Now it just
Tanks.
Yeah.
Right? Like maybe, if there's some other evidence, some other witness, and maybe we'll be able to recover from that. But suggestion, and that's what I said, at any point of this process could influence the child's perceived credibility, can affect the case, right? And that's, I mean, there could be some information out there for parents who, children to disclose to them, like how to respond to that. But it's hard enough to get forensic interviewers to adhere to good interviewing protocol.
Right. And they're not emotionally invested in the
Right.
child.
And so a parent's first inclination is to be like, what happened? The child could be like, I need to tell you something. And you're like, oh no, I fell down at school today. Phew, did someone push you? Was it that Lily?
Exactly, because that's how we ask all the
Yeah.
time.
So, there that will be some of the evidence that comes into court. When did that allegation take place? What was said at time one? What was said in the forensic interview? Right? And the defense is going to have access to that information. All right. How are we for time? Questions? Any more questions? Wes? Yeah.
So this was only, the research was only about criminal proceedings.
Right.
Not about like family court.
Right.
So I know in family court is where the vast majority of abuse allegations occur, and specifically false abuse allegations occur in family court during divorce proceedings. Do you think that sort of cross-examining like a child who's been brought up in that case has merit because
Right.
there is a much higher proponent of false allegations?
Okay, so the context in which we do see the highest number of what we think are false or unsubstantiated allegations, because again, you're not really going to know, how do you know it's false? If the child retracts, does it mean it's false? Because children who were actually abused will retract what they've said. Because suddenly the reality hits that there's a lot of consequences and I'm scared and I don't want to go to court. So children who are actually abused could retract. Children who were not abused could retract, right? So we don't really know for sure what a false allegation is, right? We do think that in that context of, custody disputes, that's where we would see the highest number of false allegations. Interestingly enough, I read a study where it was more likely the male parent that was coaching the child in a false allegation.
Sexual allegations? Or
Yeah.
just in,
So against a new partner. And so this is completely counter to some of the stereotypes that are out there, what people would believe happens in false allegation. And this one study is old, it probably needs to be redone, but what it found is that in those unsubstantiated allegations, it was more likely to be the male partner that was encouraging the child to make those allegations. So, but even then, they're not thought to be really high. So yes, there could be, okay, here we go, we have a bitter custody dispute and a child is alleging this. Sometimes the marital breakdown is a result of an allegation, right? A child comes out, they make an allegation of sexual abuse, it could result in the divorce, right? So just because there is a divorce setting, you need to be really careful to assume that that's a false allegation, right? Yeah.
What if the defendant is a child or a teenager? How does that work?
That's really interesting. So I've read a few cases of them. They still would not be published. So their name doesn't get published. They're going to be charged under the Young Offenders Act. So they would be protected from that. And so often what happens is the accused person doesn't take the stand. So they have the right not to take the stand. So I'm going to guess that if you have a youth perpetrator, in most cases the defense attorney is probably going to advise that youth do not take the stand. But if they do take the stand, they will be cross-examined by the prosecutor. Right? And they're a youth, they're a child. And so I think this is such an interesting area. In I think it's Ireland, they will assign what they call an intermediary, so that's the communication facilitator, to youth suspects as well. So they will have that benefit of having that support, that communication support in court when they're being tried for a crime, which I think is equally as important and kind of where I'm hoping.
We don't have that.
We don't have that here. No, we don't. Not that I know of. That's kind of where I'd like my research to go. Kind of like the use of it. Why don't we have intermediaries here? Right? And I'm not sure. Maybe we do. I do have a colleague of mine who worked for a child advocacy center for quite a while, and so I've never heard her mention one. She talks a lot about support dogs. Support dogs are a new big thing during forensic interviews and in court and stuff like that, but no communication facilitators. So I think it's really interesting, and I think it'll be interesting to look at what people think about having an intermediary, because many people that I talk to, they don't realize that when a young child as young as 4 goes to court that they're going to be cross-examined. I think people it's just not something they think about very often. But then when they do think about it, they're kind of shocked, right? And then even myself, I question, like, why don't we have intermediaries here? We have them in the UK. South Africa has been using them for a very long time, I think since the 90s. I mean, there could be problems, right? You could have, a communication facilitator subtly changing the question in a way that's leading the child to answer in a specific way. But if they're court appointed and they're neutral, then, hopefully that won't happen. Amanda.
I'm just picking up what she was asking. So I'm just wondering now, in your opinion, how would that affect credibility if the accused was, so what was it, the very young children are perceived to be less credible than a little bit older, but then they get less, they be viewed as less credible as teenagers.
Right.
So if it was a teenage accused,
Yeah.
and versus like not as young as the
Child.
yeah, the child, but
Yeah.
Somewhere in between, how would you have,
In terms of their credibility,
Yeah.
I don't know if I've seen any research where it's looking at a youth. There was an honor student in our lab did this really great study. There's an article out there, and what they did is they gave people photos of the accused, and they had one which was a delayed case and one which was a timely case. So it was delayed to the point where the accused would have been a youth at the time, but was now an adult, and then also an adult being tried for the exact same crime. And what they found is that there was no difference in sentence lengths between the person who was a youth at the time and a person who was an adult at the time. And there should be, according to the Youth Criminal Justice Act. they should be sentenced differently for those crimes, but people potentially looking at adults who committed that crime as a youth don't consider them as their youth self. So that's kind of really interesting and really relevant, considering that many of these crimes that are being prosecuted, those people will be adults standing trial for a crime that they committed maybe when they were 13 or 14 years old.
What if it's a case that has no delay? So
Yeah.
the juror or the judge is
Yeah.
aware that the accused is
Yeah.
also a child.
Yeah.
Do you think that was?
I think a lot of those cases are going to be dealt with through plea bargaining and some kind of restorative justice stuff. Hopefully, because it's probably not good for either one of them. But some of them will go to trial, and I'm not sure. I haven't done a lot. I'm really excited because I think in the fall I'm going to be doing some research with a student on looking at a victim versus accused person, or complainant versus accused, and cross-examination and use of intermediaries and pursuit credit stuff. So I'm super excited for that. So you can ask me in 1 year from now. See